obligations, what are the causes of non-performance of obligations? So, causes of non-performance of obligations, may either be involuntary or voluntary. Okay? So, when it comes to breach of obligations, there is non-performance of obligations. It may either be involuntary and voluntary. When it comes to involuntary, those causes which are independent of the will of the parties. So, independent of the will of the parties. So, it means to say, without the intervention of parties, of any parties, be it the obligor or the debt, or obligor or the obligee, such as fortuitous event and force majeure. While voluntary, it depends upon the will. It arises from the will of the parties. So, will of the parties such as mora or delay, dolo or culpa, dolo or fraud, and culpa or negligence, and the contravention of the tenor of the obligation. So these are the breach of obligation. It may either be involuntary or voluntary. When it comes to involuntary, it is independent of the will of the parties, such as fortuitous event, diba? Or force majeure or acts of God. That is involuntary, independent of the will of the parties. What the opposite is voluntary, wherein it arises from the will of the parties, such as mora or delay, dolo or fraud, culpa or negligence, and in contravention to the tenor of the contract, of the obligation rather. Mora. What's say mora? Mora or delay, di ba? Delay. Kinds of delay. What are the kinds of delay? Morassel vendi, mora accipiendi, and compensation more. Compensation more rather. Compensation more. So when it comes to morassel vendi, it is delay on the part of the debtors, di ba? Or default, or debtors default. Debtors default. As a delay, it is defined as a delay in fulfillment of an obligation by reason of a cost imputable to the debtor. While mora accipiendi, it is the creditor's delay. Creditor's delay. It relates to delay on the part of the obligee in accepting. It is delay on the part of the obligee in accepting the performance of the obligation by the obligor. There is refusal on the part of the creditor, or refusal on the part of the obligee, the performance of obligation made by the obligor. The requisites of mora accipiendi are the following: an offer of performance by the debtor who has the required capacity, and the offer must be comply with the prestation as should be performed, and the creditor refuses the performance without just cause. So there is performance on the part. When it comes to mora accipiendi, there is performance on the part of the debtor, and the offer must be complied with the prestation, di ba? The offer must be complied with the prestation as it should be performed. And the creditor refuses the performance without just cause. That is the very key of mora accipiendi, wherein the creditor refuses the performance obligation of the debtor or the obligor without just cause. Compensation more, it's a reciprocal. This is a reciprocal default on the part of the parties. So this is default on the part of on both parties. Default on the part of both parties, because neither has completed their part in the reciprocal obligation. So default, it is compensation more. It is default default on the part of both of the parties, because neither has completed their reciprocal obligation, like prove ownership. prove the ownership, proving ownership, and then example, proving the ownership of a ship, but um, the condition is proving ownership, prove the ownership, and once proved, the buyer will buy the ship. So since there is no proving, there is failure to prove the ownership, so therefore the buyer will not buy the ship. So therefore there is compensation more on both parties. It's a default on both, or default on the part of both parties, because neither has completed their part in the reciprocal obligation. Mora solvendi. Mora solvendi, yes, debtor's default, as emphasized here. Mora solvendi. Delay in the fulfillment of obligation by the obligor. Delay in the fulfillment of the obligation by reason of cost imputable to the debtor, or because the dolo or malice or culpa or negligence, because culpa or fraud, because of dolo or fraud or culpa or negligence. It's the failure, it's a delay. Mora solvendi, it's a delay in the fulfillment of obligation. Delay in the fulfillment of obligation imputable to the debtor because of dolo or fraud or culpa or negligence. The delay in the performance of the obligation must be either malicious or negligent, di ba? The delay may either be malicious or negligent, otherwise the debtor cannot be held liable for damages. In order that the debtor may be in default, it is necessary that the following requisites must be present. So, these are the requisites. These are the requisites in order for the obligor or debtor to be liable for damages in case of mora solvendi. Oh, the following requisites be present. Default is necessary that the following requisites must be present. 1, 2, 3. There are 3 requisites. That the obligation be demandable. Be demandable and already liquidated. Obligation, that the obligation is demandable, the obligation be demandable and already liquidated, and that the debtor delays performance, and that the creditor requires the performance judicially. So it means to say there is demand either requires the performance judicially, or first, the obligation be demandable and liquidated, and the debtor occurs delays or delays the performance. Debtor delays the performance, and the creditor requires the performance requires the performance judicially or extrajudicially. Once the creditor makes a demand, wants to make whether judicial or extrajudicial, the debtor incurs mora or delay. Hence, absent any demand from the obligee, the obligor does not incur delay. If we say delay, that is demand, delay or default is equals to demand plus delay, di ba? When it comes, to legal default, or mora, there must be a demand plus delay. So again, in order for the obligor be held liable for mora solvendi, in order for the obligor be held liable for damages under mora solvendi, the obligation must be demandable and due liquidated already. Be demandable and due liquidated, and the debtor delays in the performance. The debtor or the obligor delays in the performance, and The third is that the creditor requires the performance of the obligation, requires the obligation judicially or extrajudicially, and there is demand, either judicial or extrajudicial. Once there is a demand, then therefore the debtor or obligor is already liable under mora solvendi. Mora may occur only in obligations. Mora may occur only in obligations to give and obligations. Oh. Mora may occur only. The mora may occur only in obligations to give and obligations to do, but not in obligations not to do. There will be mora only in obligations to give and obligations to do, but not in obligations not to do. For the debtor fulfills by not doing what is forbidden him. So again, the requisites are the following in order for the debtor to be in mora solvendi. First, the obligation is demandable. The performance of obligation is demandable and duly liquidated, already liquidated. Next is that the debtor or obligor delays in performance. And the third one is that the creditor requires the performance judicially or extrajudicially, and there is a demand made by the creditor on the performance. And the debtor incurs mora or default, no? Mora or default. Because in the absence of demand from the obligee, the obligor does not be liable or does not incur delay. Next, take note that the demand may be in any form, judicially or extrajudicially, provided that it can be proved. And the proof of the demand will be incumbent upon the creditor. Yes. In any form, provided it must be proved. Demand may be in any form, provided it can be proved. And proof of demand must be made by the incumbent upon the creditor. Exemptions to requirement of demand. So this is already circumstances or situations wherein demand is necessary, but it will make already the obligor or the debtor held in default already or mora accepting. This is now, diba, sa general rule, there must be a demand judicially or extrajudicially. As an exemption, these are the situation when the obligation or law expressly so desire. Exemptions to requirement of demand. The debtor incurs mora or delay even in the absence, of the following, even in the absence of a demand rather. Debtor incurs mora or delay even in the absence of demand. So these are 1, 2, 3, 4. When the obligation expressly so declares, diba? The obligation expressly so declares. The law expressly so declares. When from the nature, this is now when from the nature and circumstances of the obligation, it appears that the designation of time, when from the nature, and the circumstances of the obligation, it appears that the designation of time, the time when the thing is to be delivered or the service to be rendered, was a controlling motive for the establishment of the contract. So again, first, when the law expressly declares so, when the obligation expressly declares so, and the third is that when from the nature and circumstances, from the nature and circumstances of the obligations, that the designation of time, when the designation of the time when the thing is to be delivered and the service to be rendered was the controlling motive for establishment of the contract. It should be from the nature and circumstances of the obligation. The designation of time for the delivery of the thing or the service to be rendered was the controlling. It's the time was the controlling motive for the establishment of the of contract. Next is that when demand would be useless as when the obligor has rendered it beyond his power to perform. Okay, beyond power to perform. In which so next, so these are the things to be taken into consideration wherein mere expiration of period that's not do not or not delay. This is under exemptions to requirement of demand. Mere expiration of period, not delay, and time is of essence. So mere expiration of period under the first and second exemptions, di ba? The first and second exemptions when the obligation expressly declares so, uh, uh, obligation expressly so declares, and the law expressly so declares, in which it is not enough that the law or the obligation fixes a period for the performance of the latter. On the expiration thereof, delay shall commence. Hence, mere expiration of the period fixed by the parties will not cause delay. No? So again, it is not enough that the law or the obligation fixes a period for the performance of the latter. Performance of the obligation. If it does not expressly add that upon the expiration thereof, delay shall commence. Oo. It is very important that in the contract, it must stipulate this phrase. Oo. It must expressly stipulate that upon the expiration thereof, delay shall commence. That is very important. Otherwise, the mere expiration, hence mere expiration of the period fixed by parties will not cause delay. Yes, it should be placed that the contract that there is a period or period to perform the obligation. Upon the expiration thereof, delay shall commence. So it must be this phrase. Let's place that this phrase must be included or must be stipulated in the contract. That is this phrase, it should be upon the expiration thereof, delay shall commence. Time is of essence. How is that? In Lorenzo Shipping Corporation versus BJ Marthel International Incorporated, the court held that in determining whether time is of the essence in a contract, the ultimate criterion is the actual or apparent intention of the parties, and before time may be so regarded by a court, there must be a sufficient manifestation either in the contract itself or the surrounding circumstances of that intention. For example, time is of the essence in exchange contracts because of the speculative and fluctuating value of stocks. How is that? Time is of essence. It means to say, in the performance obligation, it is from the nature and circumstances of the obligation that the designation of time for the thing to for the thing to be delivered and the service to be rendered. The service to be rendered is the controlling motive for the establishment of contract. The court held that in determining whether time is of essence, the ultimate criterion is the actual. It should be the actual or apparent intention of the parties. The actual or apparent intention of the parties before time may be so regarded by a court. There must be a sufficient manifestation either in the contract itself or the surrounding circumstances of that intention. There must be a sufficient manifestation either in the contract itself or the surrounding circumstances of that intention. Manifest sufficient manifestation either in the court contract itself or surrounding circumstances of that intention. Like value of stocks, as time passes by, it changes. So it must be considered. The speculative and fluctuating value of stocks, that's an example. So now effects of Morassel bending. Effects of Morassel bending. The debtor violates the obligation in point of time. If there is mora or delay, the debtor violates the obligation in point of time. If there is mora or delay. Now, there is no mora or delay unless there is demand. As a general rule, there will be legal default, there will be mora if there is a demand made by the obligee in the performance of obligation by the obligor. And so long as the obligor does not incur delay. He cannot be said to be guilty of some omission violative of the obligee's rights. Again, there is no mora or delay unless there is a demand. Consequently, as long as the obligor is not guilty of some violative of the obligee's rights, the latter has no cause of action against the former. As a result, the prescriptive period within which the obligee may bring an action against the obligor does not to run until a demand is made. So, as a result, but it is very important that a demand must be made in order for the obligor to be in default in case of delay in the performance. As a result, the prescriptive period within which the obligee may bring an action against the obligor does not commence to run until a demand is made. So it is very important that there must be a demand, because as a result, the prescriptive period within which the obligee may bring an action against the obligor does not commence to run against until the demand is made. If there is no demand, made, then therefore prescriptive period shall not run. Then let's take note this. Again, if there is no demand, then the prescriptive period shall not run. Then the prescriptive period shall not run. The debtor becomes liable for damages when there is already delay. The debtor becomes liable for damages if the obligation consists in the payment of a sum of money and the debtor incurs in delay. The indemnity for damages, there being no stipulation to the contrary, shall be the payment of the interest agreed upon, and in the absence of stipulation, the legal interest. In the absence of stipulation, legal interest, which is 6% per annum, whether constituting a loan or forbearance of money or not. So, when the as a legal effect is that the legal effect of mora solvendi, the debtor becomes liable for damages. Damages in the form of interest. Diba? Debtor becomes liable for damages if the obligation consists in the payment of sum of money. If the obligation is consists of sum of money and the debtor incurs in delay, the indemnity for damages, there being no stipulation, shall be the payment of interest thereof. In the absence of stipulation, it should be the legal interest. So, the indemnity, there will be a liable for damages, therefore indemnity for damages. There being no stipulation to the contrary, shall be the payment of interest agreed upon. In the absence of stipulation, legal interest, which is 6% per annum, whether constituting a loan or forbearance of money or not. When when the debtor incurs delay in the obligation of involving sum of money, there will be payment of interest, either agreed upon if stipulated, or in the absence of stipulation, legal interest, which is 6% per annum. Next, delay in reciprocal obligation. So, delay in reciprocal obligation, this is already the compensation more. Compensation more. Compensation more. It's the simultaneous performance as a rule. Simultaneous performance. Otherwise, default, it is a default on both parties because neither of them performs the obligation. Simultaneous performance. So, it means to say all together at one time they must perform the obligation. Simultaneous performance. Reciprocal obligations are those which arise from the cause, and each party is a debtor and a creditor of the other. Yes, each party is a debtor or a creditor of the other. Arise from the same cause. Reciprocal obligations arise from the same cause in which each party is a debtor or a creditor of the other, such that obligation of one is dependent upon the obligation of the other. So, obligation of one is dependent upon the obligation, no? That the obligation of one is dependent upon the obligation of the other. They are to be performed simultaneously, like what I have said as an example, in which there is there is an agreement or a contract between seller and the buyer, di ba? Or obligor and obligee. Or let's make it A and B. These two parties. A is the owner of a ship. B is a buyer. A, they enter into a contract in which if A proves ownership using papers ownership over a ship, therefore, the seller B will buy the ship. Again, the condition is that A must prove ownership over the ship. Ownership over the ship, over the vehicle, if fulfilled, if that obligation is fulfilled, then the buyer B will purchase the ship. Okay, so simultaneous obligation. If A failed to prove ownership, then therefore B will not purchase the ship. So there will be a compensation more because neither parties complied with the obligation, because the obligation of one is dependent upon the obligation of the other. They are to be performed simultaneously so that the performance of one is conditioned upon the simultaneous fulfillment of the other. So the performance of one is conditioned. No? Performance of one is conditioned upon the simultaneous fulfillment of the other. Next, The mutual inaction, this is now the mutual inaction of the parties gives rise to compensatio mori. The mutual inaction. Inaction, there is no action. Mutual inaction of the parties gives rise to compensation mori. This principle is expressed in Article 1169, which states that in reciprocal obligations, neither party incurs delay. So neither parties incurs delay if the other party does not comply or is not ready to comply in a manner with what is incumbent upon him. So this is already um, the provisional rule when it comes to compensation moraine. In reciprocal obligations, neither party incurs delay, diba? In reciprocal obligations, neither party incurs delay if the other party does not comply or is not ready to comply in a manner with what is incumbent upon him. But from the moment, one of the parties fulfills his obligation, delay by the other begins. So if A proves ownership over the ship, over the vehicle, therefore there is now an obligation on the part of B to purchase it. Otherwise, delay will incur. Mm. From the moment one of the parties fulfills his obligation, delay by one, the other begins. This rule does not apply, however, when different dates for the performance are fixed for the obligations, in which case the rule stated in the first and second paragraphs of Article 1169 of the NCC will apply. Again, this rule does not apply, however, when different dates for performance are fixed for the obligations, in which case the rule stated um, in the first and second paragraphs of article. So there can be no reciprocal or there can be no compensation morae if they set different dates. Diba? A will prove ownership on this date. After that, for how many days? Um, B, upon uh, upon proving of ownership, upon proof of ownership, therefore, B at this period, after how many days, will now have the obligation to purchase the ship. Requirement of demand. Requirement of demand. How is that? In reciprocal obligations, as in a contract of sale now, the very common here reciprocal obligation is the contract of sale. Diba? Contract of sale. As in the contract of sale, the general rule is that the fulfillment of the parties respective obligations should be simultaneous. So, the general rule is that the fulfillment of the parties respective obligations um, should be simultaneous. Hence, no demand is generally necessary because once a party fulfills his obligation and the other party does not fulfill the latter automatically incurs delay. So, if A proves ownership, then B failed to purchase the ship or the vehicle within the given period, therefore B incurs delay. But when different dates for performance of the obligations are fixed, so this is the exemption, diba? As a general rule when it comes with reciprocal obligations, diba? Generally, no demand is generally necessary. No demand is generally necessary because once a party fulfills his obligation and the other party does not fulfill his, the latter incurs delay. The latter automatically incurs in delay. Exemption. General rule. exemption, but in different dates. When different dates for performance of the obligations are fixed, the default for each obligation must be determined by the rules given in the first paragraph of Article 1169. So, when there is different dates of performance for performance of the obligations are fixed, the default for each obligation must be determined by the rules given in the first paragraph. So, going back to the first paragraph and of Article 1169 of the New Civil Code, that is, the other party would incur in delay only from the moment the other party demands fulfillment of the former's obligation. So, is go to the but when different dates for performance of the obligation are fixed, the default will be the other party would incur in delay only from the moment the other party demands fulfillment of former's obligation. Thus, even in reciprocal obligations, if the period for the fulfillment of the obligation is fixed, diba? The period for the fulfillment obligation is fixed, demand upon the obligee is still necessary before the obligee can be considered in default. Demand is still necessary. And before a cause of action for rescission will accrue. Without a previous demand, without a previous demand for the fulfillment of the obligation, there is no cause of action yet for rescission against the other party, as the latter will not be considered in breach of its contractual obligation. How is that? Ba? In even in reciprocal obligations, if the period for the fulfillment of the obligation is fixed, the period for the fulfillment of the obligation is fixed, demand still necessary. Even there is period, di ba? There is period for the fulfillment of the obligation is fixed. Demand upon the obligee is still necessary before the obligor can be considered in default and before a cause of action for rescission will accrue. Without a previous demand for the fulfillment of the obligation, there is no cause of action yet for the rescission, di ba? Against the other party, as the latter will not yet be considered in breach of its contractual obligation. So, even in reciprocal obligation, even there is period to perform, even there is period for the fulfillment of obligation, even there is period even there is period in the fulfillment of the obligation, demand is still necessary. Because if there is no demand, demand upon obligee is still necessary. Without previous demand, then there is no cause of action. No? Without a previous demand, there is no cause of action for rescission against the other party. That's the legal effect when it comes to reciprocal obligation. The requirement of the legal effect of having requirement or having demand as requirement.